Welcome, everyone, to Autism Demystified. I am your host, Dr. Vladimir Barria, helping you to navigate autism with confidence for families. And today we have a very special guest with us, Kevin McKernan, who is a lawyer working here on Staten Island, New York. He is the owner of the McKernan Law Firm, which has proudly been serving the legal needs of diverse businesses and individuals in the New York and New Jersey areas for more than 20 years, and their reputation for helping hundreds of companies and individuals achieve positive outcomes has been the firm's goal and greatest accomplishment. And today we are going to be focusing on one of Kevin's many areas of talent and skill, which is helping parents navigate the process of guardianship for their disabled children. We have a show here which focuses on children on the autism spectrum. As a spectrum, children can have a variety of level of skills to be able to function independently or need support. But this is a very critical and crucial topic that the earlier we discuss it for families, the better off everyone will be at the end. So welcome, Kevin.
Welcome. Great seeing you again, Vlad. Okay.
Great seeing you as well. I would like to start out by just asking you in general, what are the advantages of establishing a guardianship for a child who is turning 18 years old and has developmental disability?
Well, there's a couple of things. Guardianships have been the go-to tool for a long time. However, New York State instituted a new power of attorney a few years ago. And if you use that to a great extent, that you can put in special clauses, etc., so that you may not need to go through the long process of guardian. And all powers of attorney, when we're dealing with situations like this, will give the parents or whoever, generally the parents, the ability to make a number of decisions, financial decisions, to ensure the safety of the funds, to apply for programs, etc. That ends up being very important. And years ago, the power of attorney was kind of just for certain things, and it was not able to be as extensive. The proper use of the new power of attorney would kind of get rid of the need for having to go to court, having to get attorneys, you're having the court-appointed attorney for the child, having the a court evaluator, et cetera, et cetera. And it's a long process. But in consulting with us, we'll probably be able to come up with different clauses of power of attorney that the parents could, really do a long term. But this goes in conjunction with other things. Once someone turns 18, unless there's some things in place, parents can't even talk to the doctors of the 18. So what we always suggest is that the child sign a HIPAA release form, on a healthcare proxy form, and we go further than just the standard form. We go, because when you're dealing with special needs, you're dealing with more than just a regular doctor or checkup or anything. You really have to get into what exactly the best treatments would be, how the child is progressing, and the like. Power of attorney doesn't control any type of health issues. So it's really financial and personal issues. The health issues have to be dealt with separately. But it's all part of a plan, a process that parents should really consider. It's like no time is better than the present. A lot of times, want to put off decisions, but all of a sudden, something happens, and all of a sudden, it's unfortunate, but I've seen it. Doctors can't talk to the parents, and it's especially true when a child goes away to school, to college, or somewhere else. It just moves out away. And something happens, and the parents can't even find out any information. So we make sure that those things are done so the parents can understand what is going on and make appropriate decisions with that. Now, in the event that things happen and you do need a guardianship, we do that. We do that regularly. We try to make it as painless as possible, but it's a process. It's a number of court proceedings, and it takes a few months at best. So,
okay, so by working with you, basically families can save themselves the time, the expense, the stress of going through a longer process when something more streamlined may be more beneficial to them. Does that
right.
sound correct?
Yeah, that is correct. That is correct. So you hit the nail on the head. Sometimes guardianships are more appropriate, but we try to make sure that that the power of attorney will at least allow, while guardianship is proceeding, the parents can make some decisions on everything.
So aside from
we
ahead.
hope that the parents have set up a special needs trust for the child, because as you are well aware, and everybody should be, if someone is able, not even that they get the money, is able to take an inheritance or take a gift, the government will look at that and look to cut benefits. This is especially true when grandparents want to develop a trust or a will for their grandkids, and the grandkids are younger, and they don't even think of that. And things happen down the line. And what the federal government and state government have said is that even if the special needs person rejects the money, says, I don't want it, the government will say, well, no, you could have had it, so we're going to pretend that you did get it. And that is something that people don't know about until it's too late. So we always talk to grandparents and say, well, I know the grandchildren are young, but you never know what happens. We just put in clauses that allows the executor or executrix to make a determination that if it's better that it goes into a special needs trust, it goes into the special needs trust will set up in the will.
So there seems to be like a tangled web of rules and regulations around this whole process. One of which is, at least looking back at the health versus financial aspects of it. One thing that is a commonly asked question is, what is the relationship between, or how does it affect an ability to get power of attorney for a child versus to have guardianship when you are also have a Medicaid provider responsibility in their life as well? Like, what is the interplay there?
Well, what we try to do in the power of attorney, put in specific clauses allowing for applications for government benefits, allowing for payment of bills, payment of premiums, stuff like that, and to try to prevent it. Sometimes, a facility, if somebody's in a facility, they may petition to be guardian to ensure their financial payments are made. We try to not let that happen. It's a process, and it does take some time coming into our office, but we make it as painless as possible and explain things in great detail so everybody, including the child, especially understands what to do. We take time and have another staff member talk to the child to understand what they're doing, and it works out.
What is like a worst case scenario for a family? Like, let's say they didn't hear the show. They have not had access to information about like their options to help secure their child's future and decision-making process. What happens if a child has already turned 18? And the parents miss their window to get power of attorney? Are they still able to do that going forward?
Well, yeah, you can, even if somebody's over 18, you can still do the
Okay.
power of attorney. In fact, you have to be over 18 to sign the power of attorney. But let's say worst case scenario. Child is 19, there's not a power of attorney, there's not a HIPAA, there's not a healthcare proxy, there's nothing. Child suffers let's say a stroke, a serious stroke, like 21, 22 or something else. They're in the hospital. They're going to have to go to rehab. The parents can't find anything about it. Bills are piling up. There's nothing do. Then you need to rush into court and get a guardianship proceeding so you can make some decisions. And you try to do it as quick as possible. But that's like a worst case. And you're getting phone calls, are you paying this? Where's this money coming from? Are you going to apply for the government programs? How do you do that? Oh, we'll take care of it, But, who knows if they do? You're going to have to apply for different things. And the people are going to say, well, how could you do it? Because you don't have a power of attorney, you don't have a HIPAA, you don't have anything, and that's when you have to rush to court.
So basically, if you have a child, though, yeah,
and this is especially if the child is out of state, going to college somewhere, because then you have a question. The New York guardianship, then you got to get it filed in the state. Let's say it's in North Carolina or something, and those procedures, are there, and the medical provider may oppose it, and you open up we try to prevent the can of worms from being opened.
Got it. So my last question is, if a child, like even after they turn 18, what if you have a child who is very significantly affected by their disability, that they are not, don't have the competency of even signing, of being aware that they're signing a document and what it means? What happens in those cases?
Well, as long as they were competent, and signing a power of attorney is a lower standard than executing a will. As long as they sign the power of attorney, while they're competent, that remains into effect. And so let's say they get quote unquote worse and they really can't do anything. That power of attorney, as long as it was executed properly, remains in effect. It does not stop just because the person is now more serious disabled. And this is, we're talking about children basically, but it does also fall to adults. If someone signs a power of attorney when they're 70 and all of a sudden get Alzheimer's dementia at 75 and they can't do any of these things, that power of attorney is still in effect. So it's not only for the young, it's for the old too.
Kevin, can you please tell our wonderful audience how they can contact you and find out more about you? I will make sure to put all of your contact information in the show notes for this episode, but sure. What is your preferred method of contact?
Yeah, if they send me an email, that'd be fine. It's kevin@kmckernan.com, which you will, of course, have. Or they can call my office, 718-317-5007, and we'll schedule an appointment for them to come in. And after they do that, we'll get their information, and we'll send them some materials that explain the power of attorney, special needs trust, etc., and a questionnaire so we can, see what exactly their needs are.
Thank you so much for joining us today, Kevin.
It's a pleasure.
A wonderful opportunity to speak with you and to learn from all of your decades of wisdom and experience of going through the process and being a very respected and well-known person here on Staten Island and throughout the state and multiple states, as a matter of fact.
Yes, it's been a pleasure serving the community of Staten Island especially. And one of the joys of doing what I do is really helping people. We try to make a complicated process easy to understand. And we've been successful in that.
Well, that's beautiful. Well, there you have it, everybody. This has been Autism Demystified with your host, Dr. Vladimir Baryev, autism pediatrician, specializing in helping parents navigate the process of caring and raising their child on the autism spectrum in a holistic manner. If you're interested in learning more about the services that I provide and how I care for children, please don't hesitate to call my office. The number is 917-819-5056. And the show notes at the bottom will have all of Kevin's information. Thank you and goodbye to everyone.
Thank you.